clauses 2 to 8 are all provisions geared towards ensuring and maintaining this independence. To determine whether the courts-martial or the persons manning the courts are independent in the exercise of their judicial powers requires an examination of the laws and procedure under which the courts operate. From this, one can then determine whether a reasonable person familiar with the Constitution, the laws setting up the military courts and their structure would perceive and be satisfied that these courts are independent. Counsel for the appellant emphasized that fairness in the General Court-Martial is assured because the members of the General Court-Martial take an oath to uphold the Constitution and administer justice. Indeed, it is the norm that judicial officers take an oath to render justice, and this places the duty on the respective judicial officers to exercise the judicial power with independence of mind and impartiality. However, this subjective undertaking of exercise of duty is only truly guaranteed when it operates alongside the objective safeguards that can satisfy a reasonable person that the appearance of partiality is eradicated, and the judicial officer is acting with an independent mind and is insulated from extraneous factors such as an undue influence. Impartiality is determined by the absence of bias, objective or perceived. In this regard, objective impartiality is akin to independence. The test for impartiality is, open quote, whether a reasonable, objective, and informed person acting on the correct facts will reasonably apprehend that the judge has not or will not bring an impartial mind to bear on the adjudication of cases, close quote. C, in re an application for recusal of Honorable Justice Alphonse Owiny Dollo, Chief Justice, miscellaneous application number 3 of 2021, arising from Presidential Election Petition number 1 of 2021, Chagulaini Sentamu Robert against Yoweri Kaguta Museveni, Ibuagura, and 2 others. It is clear that in impartiality, appearances are of importance in order to satisfy the subjective requirements. See also the case of R against Spear and Findlay against UK. In the instant case before this court, the respondent makes no allegation that the members of the tribunal were actually biased. I would thus recast the issue of independence, impartiality, and impartiality of the members of the court as follows. Whether a fair-minded and informed observer would conclude that the safeguards for a fair hearing in the court-martial were adequate to guarantee the independence and impartiality of members of the court-martial. What is manifest from an examination of our laws is that, with regard to courts-martial, 1, with the exception of the CMAC, Court-Martial Appeal Court, there is no legal requirement for a person qualified in law to form part of the quorum. Before I proceed, I want to understand that apart from the Court-Martial Appeal Court, the others who sit and carry out judicial function, there's no requirement for them to study law, to be lawyers. So it's like there's no requirement for anyone to go to a theater and operate on a patient. And pick, you can pick the most famous lawyer in town and give him those names, I don't know how they call them. Or you can pick the Chief Justice of Uganda, give him 12 people, not even 12 people. He would have been carrying the rank of a corporal in charge of a section, and you place him at the board of DRC to protect Uganda against possible enemies. He has never touched the trigger of a gun in life. He doesn't know map reading. He doesn't know how to win civilians to his side. He did not have the 9 months training that is required, the basic training that makes you be a soldier. and get the first rank of private, I think the first rank of recruit.